Hello, everybody.
Okay, all right, and then we are on the record in the matter of the City of Wyandotte versus Charles Jenkins, 241565.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf of with my client, who's presently in Wayne County Jail for purposes of sentencing. He is present, Your Honor. Please state your name, sir.
Charles Winding is the second, Your Honor.
All right, thank you. And so today's a date scheduled for sentencing in this matter. And counsel, you have an opportunity to give recommendations to the
Yes, we have gone over it today, Your Honor. There are no substantial corrections or deletions. My client and I have talked about it. He's been in custody, Your Honor, over 30 days. He thinks about 33 days. And he tells me that his parole officer says that nothing can be done further into the case that he's on parole for until this case is completed. The plan is to put him back at Team Wellness. That's what we're hoping that he gets there. He was doing well there. In fact, he told me that they even got him working for them, actually at a paid position at Team Wellness. So he's a patient and he does community service out of there too. So he's doing well there, Your Honor. He's 38 years old. He has a job, I said, with this addition. He does when he's out, he does a lot of construction work, freelance. And we would hope we would adopt the recommendations. It says incarceration, of course, but I would ask for time served, Your Honor. But I told my client fines and costs and the rest of the sentencing, including his incarceration, is in the discretion of the court. Your Honor, we leave it for discretion.
Well, sir, I reviewed the pre-sentence report and recommendation. You are wanted 3 times, you have 14 bench warrants, you have a significant criminal history dating all the way back to 2004, which your charges are all over the place, but yours are. However, the majority are involving alcohol and theft, which.
May I speak, Your Honor?
Is what you're charged with here, yes, sir?
Yes, ma'am. I would just like to say, as far as what's been going on with me in life, my brother died in my house about probably 15 years ago, and ever since then, I've been basically not caring. But I'm in the Wayne County Jail now, and I've been coming here for over 20 years. And for the first time ever, I got off the mental health floor onto a regular floor because I'm at Team Jefferson, Team Wellness, and they actually hired me there. I was doing community service, and it's an old building, so they hired me to renovate it. And I've been doing really good there, better than I ever have in my life. And I asked that I can please go back there as soon as possible. My parole agent said that once I'm done with this case, that I can go back to Team Jefferson where I was at. I did relapse, and I'm sorry. I got hit by a car right before I went into this gas station. Into the 7-Eleven, I got hit by a car and broke my nose, and I didn't have no shoes on. And when I walked in, the guy didn't want to sell me a beer because I didn't have any shoes on, and I was hurting from my nose being broken by a car accident. That's why I took the beer, Your Honor. I even put the money in the counter.
Pause. So instead of going across the street to the hospital, you went into the 7-Eleven to get beer.
They dismissed, they released me from the hospital doing nothing. They gave me 2 Tylenols and released me. I walked out of the hospital and went to the 7-Eleven and asked to buy a beer. And I had the money on me. I left the money on the counter. And the guy even told me when he came out, when the cops got there, that he was sorry. He didn't know that I just got hit by a car, or he wouldn't have called the police.
Okay, well, it's also alleging that you dumped beer on the poor guy. But in any event, what the court's going to do is the court's going to adopt the recommendation. The court's going to order 90 days jail, credit for 35 days. I counted when I was reviewing the file, counsel, 35 days was my count.
Thank you.
So, and I'm going to waive the fines and costs.
Thank you, Your Honor.
So what is the sentence, Your Honor?
What's that?
What is my sentence?
90 days jail, credit for 35.
Okay, thank you.
Good luck to you, sir. Okay, Mr. Gettner?
Yes, Your Honor.
All right, we're going to go on the record in the matter of Beverly Harvey versus Daniel Martin, 2401884. And counsel, your appearance, please.
Good morning, Your Honor. May it please the court, Patrick Guttner, P70106, appearing on behalf of the plaintiff Beverly Harvey in this matter.
All right, and Mr. Martin, your name for the record, please.
Good morning, Your Honor. Daniel Martin, appearing as an individual and a witness for Melhouse Ice Cream Company.
Okay. What's your position with Melhouse Ice Cream Company?
I'm the owner.
Okay, that
I'm
wasn't.
the registered agent, Your Honor.
Okay. Okay, so today is the date scheduled for a motion and a pretrial. So let me just see here. And just for the record, I'm going to state that I know counsel, I know Mr. Gettner. Our kids are friends, but I haven't seen him outside of court in quite a while, and I haven't had any communication regarding this matter. Counsel, sir, do you have any objection? Or counsel, would that be accurate?
That is accurate, Your Honor.
Sir, do you have any objection to this court continuing to preside over this matter?
I have no objection, Your Honor.
Okay, so Mr. Martin, you filed the motion, correct?
Correct, Your Honor. I filed a motion summary disposition of dismissal for Dan Martin as an individual.
Okay, so sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, so, and here's where online is not fun. Okay. So, sir, you're asking to be dismissed, you're asking for yourself to be dismissed only, correct?
That's correct, Your Honor. And I'd be happy to explain. At no time has the plaintiff alleged that Daniel Martin personally guaranteed a lease. And there's no reason to continue Daniel Martin as an individual on what I'll call a fishing trip, causing undue cost. Once Melhouse has an attorney, and keep in mind, we've only had about 10 business days as Melhouse to secure an attorney. But once Melhouse has an attorney, Daniel Martin can always be brought back in on a theory of fraud or some other theory, which is a very high bar to seek. He's naming me as an individual with no theory or facts, and incorporated into the motion is the lease. I did not, as an individual, guarantee the lease, Your Honor.
Okay, counsel, did you file an answer to this motion?
I did, Your Honor. I spoke to the clerk last week after it was filed, and as quite frankly, as a courtesy to the clerk and to the court, I filed a brief response outlining some of my objections to the motion. However, I've explained to Mr. Martin, and the court is aware, if the court's going to entertain the motion as pled as one that's actually pled for summary disposition, then I'm entitled to 28 days to respond.
Well, that's correct, but also I've noticed that the motion filed by Mr. Martin does not have the required affidavit attached to it.
Your Honor, there's several, and again, I'm not trying to be negative, you know that, and I've explained this to Mr. Martin. There's several issues with the pleading, which is why I was compelled to file something briefly. The case number is wrong. He cited no legal statute. He cited facts in dispute, no affidavit. There's a number of things that are wrong with this pleading as to where it couldn't be granted today anyway.
Well, that would be correct. So, Mr. Martin, it appears as though either you're doing your own research and representing yourself, or somebody's been assisting you with this. But there's quite a few defects on your motion for summary disposition. Your request for summary disposition does not even have any sort of legal basis for which it's being requested. I don't know what I'm supposed to be basing this on. That's one thing. And then I don't have an affidavit attached, which is required. And the other is the notice to the opposing party of 28 days notice. So let me ask this question. Mr. Gettner, you supplied a copy of the lease with your complaint?
I did, Your Honor.
No, hold on, I don't see that attached. I see.
Your Honor, if I may, there's a copy.
Just one moment, please.
Yep.
Mr. Gettner, what are you relying on that would name Mr. Martin as a defendant?
Yeah, throughout the course of this process, I've had, and I explained this to Mr. Martin in the breakout room, I've had several communications with him regarding both some alleged equipment that was left, the possession of that equipment, what entity owns that equipment. The finances are at issue as far as what was owed and due. And he himself will tell you that's a fact in dispute. So my request would have been today that, yeah, possibly, via the terms of the lease, he's not personally liable, but I have to keep him as a named party in regards to the other matters, because my request is going to be for some discovery. And I told him at some point down the road, his dismissal at the, if the court decides to issue that, if it's properly pled, I'll defend that. Then my clients also have, based on the outcome of discovery, their possibility of pursuing the opportunity to pierce the court prevailed that there was wrongdoing on behalf of the LLC when Mr. Martin was a tenant. Now, only discovery will tell me that. And for those reasons above is why he's named.
Okay, but
there's no question it's a violation of the lease. That's undisputed.
Okay, but the complaint alleges that Mr. Martin has vacated the property, correct?
Pardon me, he vacated the property, but for some property that still remains inside, which is why it's a landlord-tenant matter, not a general civil.
Oh, that was my next question. Okay, Mr. Martin, you're intending to, well, you've relocated, correct? You vacated the property?
The business is closed down.
So
And
my question is, you vacated the property, is that correct?
Correct, August.
Okay, and so are you in agreement that you're going to get the balance of the property out? That's yours?
No, but that's a matter for Mel House, which we'll need an attorney for.
So you're not going to remove any of the property that is still?
I'm sorry. We've tried several times. To remove the third party's property owned by Leader Tool. The landlord has said that he is keeping, via text message, said that he is keeping the equipment due to unpaid rent. So he is claiming that he now owns it due to unpaid rent. And it's third party equipment.
Again, Your Honor, that necessitates Mr. Martin individually as a matter. I have no documentation relating to anything he just said.
All right, well, we're definitely going to have to set this for another date, and it's definitely going to be in person. So,
as far as an individual, I've heard nothing that other than theory of breaking a corporate veil. I would think that's a matter for Mel House and discovery. So I would like to still ask if we can remove Daniel Martin as an individual.
no, sir, not this particular juncture, because the motion for summary disposition was not properly filed. I stated, you don't have.
Understood, Your Honor.
You don't have anything in there regarding any legal basis that you're asking this court to determine, to grant your motion. You don't have the required affidavit. There's not the required 28 days notice to the opposing side, so there could be an answer filed. So, let's see here.
Your Honor, if you're considering time, could we please take into account the length of time for me to get the discovery to Mr. Martin and Millhouse, and then his time to respond?
So why is Millhouse not represented today?
We've only had 10 days based on Mr. Gernter's filing to try to retain counsel. We've not had 21 days to even seek counsel, especially with the holiday week prior. We will have counsel, and at this point, we'll actually have counsel for Dan Martin as an individual, which will add to cost, and we'll have counsel for Millhouse Ice Cream. Should we adjourn this?
Your Honor, obviously, I have no objection to Mr. Martin retaining counsel and the time he may need to do so.
Okay, well, let's set this for January 10th. Well, actually, let's do January 7th at 1:30 in the afternoon.
Your Honor, we had a poor internet connection. January
7th at 1:30 in the afternoon. That's in person.
Thank you, Your Honor.
So
Thank you, Your Honor.
if you're retaining counsel, you need to make sure that you're giving counsel that information. Okay, we'll see you back at on January 7th at 1:30.
Thank you, Your Honor. I appreciate
Thank
your
you,
time this
Your Honor.
morning.
All right, thank you. Have a good day.
Be safe, be well, sleep sweet, and much love.